close enough.
Yeah. My name is Mike Moyer. I'm the author of Slicing Pie. I'm sitting here with Matt Rosetti, one of my favorite slicing pie attorneys. Matt, we're talking about the slicing pie model and your experience. You told me earlier that you spend a lot of time dealing with founder disputes. Tell me about that.
I deal with 80% of my practice revolves around founder disputes. 9 out of 10 times, it's the same exact circumstance where we have a group of 3 people or 4 people, it doesn't matter how many there are, and they choose a conventional equity model at the outset, sometimes put in cash, but future circumstances change how much each person can continue to contribute to the business. A perfect example is 3 people start a business. Husband and wife are part of this team. The person who's driving the business doesn't have that much cash to put into the business, but the husband and wife do. Husband and wife put in $10,000 per party. After 6 months, husband and wife have multiple children and a major life event. At this point in time, the husband and wife are no longer contributing time to the business, whereas the third equal partner is putting in 80 plus hours per week.
So he's doing all the work, they own 60% of the business. Or
Correct, and it's 1 vote per partner. So there's no way at that point, other than litigation or arbitration, to try to find an equitable solution to.
And that's what it's come to your clients. That's a kind of typical client thing.
That's a prototypical example.
Got it. So the basis is the same thing I describe in the book, is the whole idea of going into something using a fixed split, a traditional model. Things change, and then you got to go to court to figure it out. Or
correct. The traditional model assumes that we actually have a crystal ball and we can see the future and we know exactly how much we're going to be able to contribute. And we're also assuming that there's a market need for our business.
Have you ever met anybody who can predict the future accurately?
A couple people have been pretty close, but not with 100% accuracy.
So we met a few years ago, and you were exposed to the slicing pie model. What was your first reaction when you heard about it?
My first reaction was I was interested in the model because I was actually an entrepreneur before I was an attorney, and my previous business failed because I could not get one of my partners to give up some equity in exchange for a larger contribution of time, effort, and resources from our technical expert, our CTO.
So you wanted to give some equity to somebody else?
Yes, I was.
The situation we had, maybe a 50-50 deal, you brought a third person.
Correct.
They wouldn't cough it out.
Correct.
I've seen that a lot, and of course 7 to B2, which is why I created this model.
Yes.
What are some of the concerns that maybe you had initially seeing it, maybe you think other attorneys that you talk to have about the slicing pie model? My
concerns were that the primary concern that I had is a lack of history. As attorneys and accountants, I think any professional that works in business, we like settled expectations. We like to know that there has been a Supreme Court case or that we have a written statute or regulation that tells us here's exactly what we can do and here's what we can't do. And my concern with slicing pie was, if we have a hypothetical equity split, how will the law look at that? And I also had, I'm not a tax expert or a tax attorney, but I also had some tax concerns because as a business, generally speaking, most businesses are worth nothing during the first few years.
You can't divide by 0.
Correct. But my concern was that if the business has some income, who realizes that gain? Right.
And so, of course, these are all things that have been addressed by you and some other attorneys all over the
world. Correct.
How have you managed, do you do a lot of slicing pie consultations today?
I do dozens of them every month.
So you're one of the lead guys that I send clients to for my website.
Correct.
Matt has a contract and a consultation agreement that you can get on slicingpie.com.
Correct.
And I send you clients, and do you also introduce you to your clients that I haven't introduced you to?
Yes, yeah. I actually still now have clients contact me just from my website, from finding me online from articles and stuff, not even through slicingpie.com.
So what are some of the concerns that they have about the slicing pie model?
Generally, they never have concerns if they're experienced entrepreneurs.
If they've been burned once before, they say, hey, this is it.
This is perfect.
Got
yes. The inexperienced entrepreneurs, first-time entrepreneurs, they'll usually have done a free consultation with an attorney who's not familiar with the model, and they're not comfortable with it.
Have you had to unwind fixed equity splits using the slicing pie model before?
Yes, I have.
Retrofit kind of things? Has that worked out better for the founders once they get comfortable?
Once the terms are settled, yes. But if you can't come to terms at that point, you a lot of times just have to walk away.
So one thing I like to talk about is, regardless of the legal underlying stuff, the slicing pie model will tell you what the split should be. So it's sort of, I call it a moral agreement, doing right by people who help you get to where you're going.
Correct.
So once people go into battle, if they do, they can at least see what it should be.
Yes.
So you know someone's asking for more than they deserve, or you know someone's getting screwed,
Yep.
essentially. So this model helps at least tell the true story on top.
The beauty of it is it's moral, ethical, and mathematical in nature.
Which makes a lot of transparency, you mentioned earlier.
Exactly. The key to building a good, solid organizational culture, in my experience with every business that I've worked with, whether they're an LLC, a corporation, a partnership, or a professional corporation, there has to be transparency and trust between the partners. Anytime, even in a conventional business where you have people are keeping secrets in a small organization, you might as well shut the business down and wind up.
Because the founder disputes are just
Correct.
And I've been in those businesses before
Yes.
where the equity agreement drove me out of the business more
Yes.
than once, and the company failed.
It's not uncommon.
So tell me, have you ever had any customers or clients fail because they used the grunt fund model?
Quite the contrary. I would say that they failed because they didn't use the
They
grunt
didn't
fund
use it.
model. Yeah.
Have you ever had any clients go on to raise Series A and some major investment?
Yes, several.
So what's the process where a grunt-funded company would go about talking to a venture capitalist?
When we go speak with either an angel investor or a venture capitalist, we treat the business as if we're operating under conventional equity split. Whether that be an LLC or a corporation, that's going to vary. It's a whole other discussion as to what entity's right for each business, because there are some different factors that come into play there. But what you do is when we approach the investor, we say, here's X LLC, here's what our cap table looks like right now. If that investor wants to proceed with due diligence, then at that time we have the grunt fund split, essentially.
So you don't explain the model to them when you're pitching.
Because it's not relevant.
Right.
It's absolutely not relevant.
So what it delivers is a clean, conflict-free cap table, which
Correct.
is what investors want.
And the one interesting response that I've received from a couple investors is they really liked that we had this history of contributions from each of the
Right.
key partners, because one of the measures of a business, from a business valuation perspective, is key partner discount. And if I'm an investor, I want to know that my investment's safe, and this is why most investors, VCs or even angel investors now, are going to demand that you have a vesting schedule for all the key partners involved, because they are not going to give you $1 million when they have to worry about your CEO disappearing in 6
Right.
months, right?
So what you're referring to is this record-keeping process that goes on in Slicing Pie, and really in any organized business keeps records.
Yep.
That gives a lot of insight for the investor to say, hey, these guys really are working
Correct.
hard versus not working at all.
And knowing that each party is being compensated fairly and you're avoiding potential future conflicts because of equity disputes.
So when they get to the table, the investors that have looked behind the curtain know that things are...
Yeah, the ones that have actually seen the whole history, right? If we go through and we show an Excel sheet that's updated either on a monthly, quarterly basis, each team does things differently. Some of them do it on a daily basis and freeze frame exactly where the equity's at every single day. If you do that, any investor or attorney for that matter, or accountant or whoever is going to be participating in your due diligence process, an underwriter, for instance, is going to appreciate that.
Makes it a lot easier to have some records.
Way easier.
And I see a lot of startups start and they don't want to keep records. It's too hard. They want to kind of be, footloose and fancy free, and they causes a lot of
Yeah,
problems.
I think
Especially
lawyers are
when-
known for not wanting to track time. We hate it.
I see intellectual property cases where having a diary really helps out, and having
Absolutely.
records of what you actually did and what you actually contributed.
Correct.
Really have a picture. Otherwise, it's a he said, she said kind of thing.
Yes.
Have you had clients who have been talked out of the slicing pie model before, and you've had to kind of turn their head around?
I've had clients who have consulted with other attorneys that did attempt to talk them out of it. And in those circumstances, generally what happens is the one partner, or potential co-founder, I should say, if they're that concerned about using this framework, then everybody's replaceable.
Right.
Let's put it
I've
that way.
seen that too, where they
Yeah.
use it sort of as an acid test to say, do I want to work
Correct.
with this person?
Yeah.
If they don't want to use this model, it sometimes is an indicator that they're willing to benefit at your expense, for instance.
Correct. Correct.
So you've written some agreement templates that you help clients implement, and they have a consultation that goes along with that, your first consultation. What does that look like for clients?
The consultation's a 30-minute discussion where I answer general operational questions about how you administer a grunt fund agreement. And the common advice and common questions that come up are usually about the major thing is the clawback provision, which I think is one of the most fair clauses in the agreement, which basically states that if somebody leaves for good reason and exits the company prior to the company reaching what is called a grunt fund split, that person will claw back within a certain period of time if there's a liquidity event.
Right. So I can't buy your equity back for $2,000 and sell it for $1 million the next day.
Exactly, exactly. That, which is always going to be a
Right.
significant
Fairly
concern for anybody involved.
Right.
Yeah.
Well, great. I appreciate you talking to me today. You can be reached on slicingpie.com under the attorney section. And how can I
Correct.
reach you? What's your website address?
Sentientlaw.com. That's sentient, S-E-N-T-I-E-N-T, law, L-A-W.com.
Matt Rosetti, Sentient Law, thank you very much for being here. It's been a pleasure working with you.
Absolutely. My pleasure. Thank you.
That's it.
All right. Cool.